Okay. Your questions will not be mixed, so you don't have to worry. Okay, for your exam. So if you have a question, senang for you to go through. All right, this one I show you law of tort. It's not here good, so let me see if I can get it for you. Yeah, it's here. It's on topic, 41, 42. Okay, I got it. All right, ini soalan dia. So example, this is a question. Okay. So you can see the question roughly, so you can know. No, not. Okay. All right, this is an example question. Okay. Show you this thought. All right, that is duty, okay. So it starts with 37. Yeah, so here we have a lot of cases here. You want minute? Okay, lecture and liability in negligence. Okay, that's it. So here's the start. Okay. So you worry about the question I gave you and the text. We will use our text. Okay, these notes are enough already. No worry. Okay, those baru masuk, you just type here. Okay. Aim of tort is compensation, corrective justice, deterrence, vindication. So aim of tort is compensation. The main aim of tort is to ensure the claimant recover any loss and all that. Corrective justice, this is based on the concept of the fair for the claimant to put the position. Deterrence is deter other people from committing a crime. Vindication, the claimant will have to pay. So personal liability to be personally liable. So joint tort causes, you can be liable independently, serval and all that. So we are looking for Donahue and Stevenson. So we go because this area is very, very wide. It's a UK law. So UK law, Malaysian law for tort is the same. For contract and all that, we have slight different because we have our act. So this is the negligence, The aim of law of negligence is corrective, compensation, deterrence, vindication. So it's too wide. We will jump here. Tak perlu so much. Okay. Establishing liability. This one is vicarious liability. Okay, tada. Vicarious liability, I come back later for you. Because you must know the general duty of care first. Okay. All right, we will start with this. All right, then. All right, so what do we have? A tort of negligence apply to claimant injury and loss caused by defendant's failure to take reasonable care. A situation where defendant owes the claimant a duty of care. So the case is modern law is Donahue and Stevenson. Successful, the element, duty of care must be owed by the defendant. This is all you take a picture. There must be a breach of that duty. The damage to claimant must be caused by the breach. Okay, these are the three things. So the neighbor principle. So you can see Lord Atkin judgment in Donahue and Stevenson. Same, Yeah. Donahue and Stevenson, Lord Atkin, same. So that's why I give the note. This is a question I show you later. Okay. Lord Atkin judgment, Donahue and Stevenson. This is the first case, 1932. Persons who are so closely and directly affected by your act, be affected by your act, that you ought to have them in contemplation. A person must take reasonable care to avoid injury to others. Okay, a person must take reasonable care to avoid injury to others likely to cause harm if they do not take care. The two elements, neighbor test. Okay, so we use the notes. Show you how to answer. Okay, go back here. Yeah, this one. Okay, I use this here. I'm going to read the question for you. Let me see if I can put the question in the chat for you, so you can take the question. Ini contoh soalan, Good for everybody. Oh, it's too white. It's too long, So let me see if I can make it half. Okay. You cannot, Why you just take a picture, Sometimes boleh, sometimes not boleh. But since we are paying, I think it should be okay, Yeah. No choice, So it's okay, You combine the thing, you can save on your side. Cannot. Okay, you just take a picture, No problem. Don't waste the time. All right, I read the question for you, Ini contoh soalan. Probably enlarge it bigger. 16. Okay, good. Put New Roman. Okay. Question 1, Okay. John, a 14-year-old boy, is a member of a football club. Okay, so we have this, no problem. He's a member. During a training session, he is seriously injured when the goalpost fell on him and hit him. All right. So John is a member, so he goalpost fell and hit him. All right. The club management had previously been made aware that the goalpost was unstable, but had not taken any action. All right. They did not take any action. Okay. So John's parents, Ian and Margaret, received a telephone call informing them that their son is seriously injured and the ambulance had been called. Okay. Ian and Margaret, so these are parents, All right. Anybody baru masuk, just please start present, Please start present. Okay. Okay. So here, Ian and Margaret arrive at the football club just as the ambulance is leaving, The ambulance is leaving. They follow the ambulance to the hospital. Margaret briefly sees John clearly badly injured as he has taken out of his ambulance. So the mother is in shock. So John undergoes an emergency operation and is unconscious for 5 days. Wow, quite serious, Goalpost jatuh, quite heavy, I think. So you can see here. Ian and Margaret sit by his bedside for the whole time. John regains conscious but spends a year in recovery. Ian and Margaret have both been diagnosed with post-traumatic stress, PTSD. Advise the parties as a right and responsibility. So we will look at the first part. Yours, I think, nervous shock, I think, I don't think we have. We will have the first part only. Okay, I will modify the question for you. John is a 14-year-old boy football. Okay, during training he seriously injured when the goalpost fell on him. Hit him. Okay. So, all right. So number 1 here is negligence. So we need to prove. The element of negligence are, number 1, the defendant owes a duty of care. Number 2, the defendant must breach the duty. And number 3, they must have caused injury. So I changed this. There must be defendant owe duty of care. Okay, the defendant must breach the duty and the failure must cause damage. Okay. must cause damage to the claimant, and then 4, you must be the neighbor. 4, neighbor. All right, these are the 4 principles. So if you can prove this, then it's very easy. Okay, so I show you the answer. Lebih kurang, okay, advise the parties. So the number short part we leave out because that one is too wide. I will modify the question for you. Okay, and the party are right and responsible and negligence. So the question concerns negligence. Negligence and special requirement for existing duty of care. So negligence, special requirement for duty of care in relation to nervous shock. Nervous shock we take out. So this one nervous shock is not in a syllabus, so we take it out. So it's a lot. All right. So we will look into the. So candidate first part only. Candidate should first explain the relevant legal law, rules, potential claimant. So number 1 with duty of care. All right. So this is number 1, duty of care. This is the model answer. 2, breach of the duty, the standard of care. 3, the causation, components of damage. Number 4, the meaning. This one tada. So 4 here will be what do you call neighbor? Okay. Neighbor principle. I will modify the question for you. So meaning of nervous shock ni tak perlu. Okay. Candidate should then apply the relevant law and the facts of the scenario, potential liability of physical injury. Yeah, this is the one. Liability for physical injury. This is what we want. Negligence. Are the elements of negligence present? Check and see. In return, nervous shock we not doing it. Right, because they mix it here, so it's a bit difficult. Okay, never mind. I'll show you one more question after. Okay, John, 14-year boy at football club. During training session, he's seriously injured. Goalpost color. Club management had previously been made aware of the goalpost. Okay. So I modified the question straight away for you. So modify. Okay, John is rushed to the hospital. All right. So that's it. Okay. John is rushed to the hospital. In an ambulance. Okay. Rushed to the hospital in the ambulance. Okay. Right. Due to a clerical mistake. By the doctor who read the wrong report. Okay. Operated doctor who read the wrong report operated And John was settled unconscious for 5 days. Okay. We need a bomb, huh? Because it's not right number. Okay, have a look here. All right, this is your question. Okay, I show your answer. Yeah, okay. Hello. Swing the club, huh? Okay. Seriously, just when the goalpost fell on him, so he will be swinging the club. Huh? So the element of negligence are this. So here, number one, to the football club. Huh? So the elements of negligence. So John will sue the football club. Huh? Okay, no problem. All right, I put it there. Put it, hold on. Yeah, it's too big. I put half. Yeah, okay. I put the other half. So proving here, the defendant must owe the duty of care, and then he must have breached the duty. Huh? Okay, so we look at this now quickly. Okay, so if you read the question, John Fortinier boy is a member of the football club. Huh? During training session, so what happens is, okay, so it's a member of football club. So during training session, yeah, those who just come in, just start present. During training session, he seriously injured when the goalpost fell on him and hit him. Falls and hits him. The club management had previously been made aware of that the goalpost is unsafe, but had not taken any action. So, okay, very fair. All right, John will be able to, the element of negligence are the defendant must owe the duty of care. Is it? Yes? Yes. Yes, huh? Why? Football club must ensure safety, safety of players, All right. So, the defendant must breach that duty. Did they breach? Yes. So, where did he breach? When the goalpost fell on him. Here is it. So it fell and hit him, so they breached that duty. So defendant must breach that duty, yes. Where happened? When the goalpost fell. Yeah, fall and hit him. Must cause damage? Yes. Yes. John is injured. Okay, John is injured. Is he the neighbor? Yes. Because football club and John is a player. Okay, so all are satisfied. So John is able to sue. So the case here will be too long. Okay, so football club. So we move on. All right, a person has reasonable care to avoid injury likely to harm. Okay, reasonable force and harm and all that. So defendant will be liable for their careless and all that. So there must be injury and the test of Lord Atkin. Okay, so what happened is later we have Caparo. So this rule was in duty of care was actually in Lord Wilberforce in two parts, but this one was overruled. Overruled by Caparo. So this is the next case, Caparo Industries. Three-part test. Okay. So Caparo is this. This is a three-part test of Caparo. Okay. So this one earlier, your case here, it will be which one? So this one will be John will be able to sue deliberate negligence. So you put here Donahue. Donahue versus Stevenson. All right. So now the thing has been changed to Caparo. So Donahue have been this case. Okay, fine tune. Caparo Industries. Caparo Industries. Check and see what is Caparo Industries. Okay, those of you just come, just type present. Okay, so Caparo Industries is where the three-part test. Okay, have a look at this. This is a three-part test. So we see what happened in Caparo.